Welcome to the 42nd lecture of this lecture series on International Arbitration Practice. This lecture is a part of Chapter 3 on responding to notice invoking arbitration and defenses. In the last lecture, we began the discussion on drafting a response to the notice of arbitration. In this lecture, we continue the discussion through the response to the notice of arbitration in Nord Stream 2 AG versus European Union, PCA Case number 2020-7, dated 26 September 2019. In the last lecture, we saw the structure of the response to the notice of arbitration and also dealt with how the response addresses the question of applicability of the relevant version of the unsettled arbitration rules. The first part of the response to the notice of arbitration is the introduction, which deals with four aspects. The first is about the receipt of notice of arbitration. In Nord Stream 2 dispute, the response stated the European Union is in receipt of a letter of 26 September 2019 by the Legal Counsel of Nord Stream 2 AG serving a notice of arbitration by Nord Stream 2 AG against the European Union under the Energy Charter Treaty. Notice that it talks about when the notice of arbitration was received, who the claimant was, and under which treaty was the notice given. The second aspect in the introduction summarizes the notice of arbitration thus. NSP2AG challenges the introduction and enactment of Directive EU 2019/692, amending Directive 2019/73/EC of 13 July 2009 concerning common rules for the internal market in natural gas. This gives the reader, including the future arbitrators, an immediate idea about what the dispute is all about. The third aspect of introduction, which is the first part of a response, briefly underscores the purpose of response to the notice of arbitration and reserves the right to challenge the notice of arbitration. It states, the European Union hereby responds to NSP2AG's notice of arbitration. Nothing in this response should be construed as an implicit admission by the European Union that NSP2AG is entitled to file a request for arbitration under the Energy Charter Treaty. We have already seen the fourth aspect in the previous lecture. It deals with issues relating to the arbitration, including the applicability of the relevant version of the unsettled arbitration rules. It states the claimant purported to file its notice of arbitration under the Unsettled Arbitration Rules 1976. The 1976 rules do not provide for filing of a response. The EU therefore files its response without prejudice to the question whether the 1976 rules or the 2010 Unsettled Arbitration Rules appropriately apply to investment arbitration proceedings currently initiated under the Energy Charter Treaty. The second part of the response is the procedural history. Here, particulars such as when the notice of dispute was sent, negotiations between the investor and the host state after the notice of dispute, notice of arbitration, request from host state to the claimant's nominee arbitrator for disclosure, etc. are mentioned. On the notice of dispute, the procedural history specifically records the call for amicable settlement. It states, on 12 April 2019, NSP2AG sent a letter addressed to President Juncker, which NSP2AG described as an attempt to reach an amicable settlement with the European Union under Article 26(1) ECT. ECT is Energy Charter Treaty. Parties then must have tried to reach an amicable settlement. So, the response would recount facts relating to the same. For instance, Para 6 says, on 25 June 2019, a delegation of officials of the European Commission and the European Union's External Action Service, led by DG Trade, met with NSP2AG's representatives. At times, there could be parallel proceedings before local courts. The facts are also brought into procedural history. For instance, the response in Nord Stream 2 AG says in Para 7, On 25th July 2019, NSP2 AG launched an action for annulment of the amending gas directive before the General Court of the European Union. This case is pending before the court. The procedural history would also deal with the notice of arbitration. Here the response states 8. On 26 September 2019, NSP2 AG purported to serve a notice of arbitration against the European Union under the Energy Charter Treaty. The procedural history also mentions regarding compliance by the claimant's nominee of arbitrators' disclosure requirements under the applicable rules, as well as any other challenge that may be raised by the host state. In Nord Stream 2 dispute, paras 9 to 12 of the response deal with these aspects. Para 9 says, on 4 October 2019, the European Union addressed to Mr. Peter Rees, QC, a letter containing a request for disclosure of any circumstances likely to give rise to doubts as to his impartiality or independence as an arbitrator. 10. Mr. Peter Rees replied to that request by email of the same day. 11. On 10 October 2019, the European Union served a notice of challenge against Mr. Peter Rees QC, appointed by NSP2 AG as arbitrator. 12. On 11 October 2019, NSP2 AG's counsel sent email confirmation of the receipt of the EU's challenge. Procedural history can be drafted in two ways, generally speaking. The first method is to recount facts neutrally, as has been done in this response to arbitration. Second method is to load the facts with host state's take on the facts. It's a matter of drafting style. More on the response to notice of arbitration in the next lecture. Till then, bye bye and stay safe.